Good evening, ladies and gentlemen. A very happy Mahashivratri and a happy Women's Day to all of you. We are joined by the most admirable and charismatic advocate, Mr. Sai Deepak. Please join me in welcoming him. Welcome to this conversation, sir. We are happy to have you with us this evening.
Thank you.
Without much ado, I would like to do a brief intro and then hand it over to the speaker. Allow me to share my screen, please. These are WiseViews leadership conversations, which we hold every Friday, 6:30 p.m. usually. And this is the 140th session for which we have Mr. Sai Deepak joining us. He's talking about litigation in India, and this will run for typically 60 minutes plus. This introduction and opening remarks for about 25-30 minutes, followed by a Q&A. Let me take this opportunity to briefly introduce Mr. Sai Deepak. He's a litigator practicing as an arguing counsel, primarily before the Supreme Court of India and the High Court of Delhi. He has been part of several landmark cases, such as those related to the Sabarimala Ayyappa Temple, the Sri Padmanabha Swami Temple, the Basmati geographical indications, and the marital rape exception in the Indian Penal Code. In 2019, Mr. Sai was presented the Young Alumni Achievers Award by his alma mater, IIT Kharagpur. Apart from delivering lectures on constitutional issues, he writes prolifically for leading newspapers and magazines. He is the author of the bestsellers India That Is Bharat, Coloniality, Civilization, Constitution, and India, Bharat and Pakistan, The Constitutional Journey of a Sandwiched Civilization. By education, a mechanical engineer from Anna University, Mr. Sai graduated with a bachelor's degree in law from IIT Kharagpur's Law School in 2009, and has carved a niche for himself as a litigator in civil, commercial, and constitutional matters. I'll also take a moment to introduce Professor Prasad. He brings about 3 decades of rich experience to the table as an entrepreneur and as an academic. He holds BTech from IIT Bombay and PGDM from IIM Kolkata. Welcome to both of you. Thank you very much for joining. I'll stop sharing the screen. Sir, as I mentioned, we are quite delighted and we are extremely thankful for you have agreed to speak with us. We will conserve a lot of time. Typically, the speaker delivers the opening remarks for about 20-25 minutes, and then we open this session for questions and answers. The Q&A is in 2 clusters. The first cluster will be taken up by Professor Prasad, and I'll come back for the second cluster. In the second cluster, we open the mic for the participants to ask additional questions that they may have. Usually, we open the mic for this interactivity. They feel very good talking to the speaker. In your case, we would love to do that more. So quickly, I want to thank you once again and request you to start the session. Thank you, sir.
Thank you. Thank you. So I'm grateful to you for persevering to get me on to this series. I think you've been trying to reach out for a while, so I'm happy to participate. I'll keep this short so that people have a clear picture of what I do, because sometimes the public perception could be misleading and may not represent the truth. So let me try and give a snapshot of what I have done so far, so that it lays the foundation for the question answers as well. The first 7 years of my practice, from 2009 to 2016, was spent at Sai Krishna & Associates, where I set up the patent litigation team, and I rose to become the associate partner in 2015 March, and 2016 June is when I went independent as an arguing counsel. So the better part of the formative years were spent in intellectual property litigation. But around that period, when I was part of Sai Krishna, I also got to dabble in multiple other areas. So for instance, I also got to dirty my hands in competition law, both from an IP and a non-IP perspective. Then I was given the freedom to pursue matters relating to economic offenses as well, because I wanted to try as many areas as possible. Plus, I did a fair amount of constitutional work, however, from an IP perspective. So non-IP constitutional work is something that I was in a position to take up only after I went independent. So by 2016, or even before that, I'd already developed a reputation as someone who could argue. So once I decided to go independent as an arguing counsel, there was greater freedom to take up a lot more matters and also take positions which nobody else has to be responsible for other than myself. So I decided to, apart from my core areas of practice, it is intellectual property and antitrust law, I started taking up briefs in multiple areas. So as on date, over the last 7 years, that is ever since I went independent from 2016 till date, that's I think more than 7.5 years now. Intellectual property is now about 60% of my practice. It still remains 60% of my practice. And the other areas in which I have a fair bit of presence would be insolvency and bankruptcy code and company law. And constitutional law, I take up hyper selectively so that these are matters where I'm in a position to bring in a slightly different perspective, at least from my point of view. Last year, that is around August 2023, I was appointed the special counsel for SEBI. So over the last 8 months or so, I have been doing a fair bit of securities fraud matter, representing SEBI before the Supreme Court, before the NCLT, NCLTs, and the High Court as well. So this happens to be my practice base, so to speak, at this point. In addition to that, of course, my public perception and my positions are fairly well known. That happens to be not independent of my practice, because as much as possible, I try and present a practitioner's perspective as opposed to what people think as a historian's perspective, because I have no illusions that I'm a historian. I'm not one. I see myself as a student of law and who also happens to be a very keen student of economics and student of history as well, or political science for that matter. So it's inevitable that I have to have some positions or opinions on certain aspects of history. And that's in addition to my own very clear personal and sometimes even controversial positions. So that's a broad snapshot. At all points of time, the one thing that I've been very, very clear about is that my sole identity is that of a practicing litigator. I don't even wish to call myself an author or a writer, because I think those tags should be used for people who earn their livelihood through writing, which is not the case with me. So I think it's important to understand that once you enter the field of litigation, you cannot have too many distractions or any other preoccupation that takes away your attention from litigation. That's the nature of the beast. And I don't say this as a complaint. It's something that I'm very, very comfortable about or with. And in addition to this, I have, I think, done 1 or 2 seminar courses for NLU Delhi in litigation. I think this was in 2017, when I still had some time. Ever since 2018, from 2016 to 2018, the first 2 years of independent practice, I had some time, but since 2018, that's not been the case. So while I would love to teach, at least as a guest faculty, I don't think I have the bandwidth anymore. So that is more or less how I see it. I think over the last 14 years, since 2009, when I started practicing, the profession has evolved significantly. And along with that, I think, and I say this with a lot of responsibility, and I don't mean to condescend, there is perhaps a falling standard of work ethic in the new generation of entrants to the profession. Okay. In every generation, you'll obviously find the top 20-30% who are as consistent and as, let's say, committed to the profession. So those exceptions don't make the rule. The question is, in general, by and large, so to speak, what is the median work ethic? And I think with growing social media distractions and other preoccupations, there is a significant, let's say, reduction in the ability to focus and commit to one thing. And that's one challenge that quite a few of my peers are facing, especially as part of law firms. Since I practice as an arguing counsel in my chambers, I don't take freshers. I typically take people who at least have 2 to 3 years of experience, so that they can run at a pace that I'm running at this stage, and I don't have the time to sit and teach anyone anymore. So what I hear from solicitors and other places is that there is certainly a drastic fall in the ability to commit to the profession for the first 3 to 4 years and keep your head down and work. In the process, I think people start looking for work-life balance right at the outset. I know this is a very politically incorrect statement to make. Mr. Narayan Murthy himself seemed to have paid the price for it, for having said that people should work for 70 hours a week. But then what else do you expect from someone who's created one of the finest brands that India has produced? That is how it's supposed to be. So I think what he said was correct. If people are interested in striking a work-life balance right at the outset in the first 4 to 5 years of practice, sure, they can. But that also means they will have to pay the price for it in terms of the subsequent rate of growth. Because this is one profession, to put it in Mr. Ram Jethmalani's words, it rewards industry. Success is directly proportional to the amount of hard work that you put in. And legal acumen and IQ are certainly important, but according to me, they are just about 50 to 60% of the entire equation. The rest of the 50 to 40% is pure hard work and nothing more, where your ability to stick to a disciplined work ethic will make all the difference in the world, because that will give you the maximum amount of, let's say, ability to extract from the same 24 hours that everybody has been blessed with. So the idea is, how do you plan your day? How do you divide your life between work and your family life, or your social life for that matter? These are aspects which people will learn as they go about the profession. I cannot comment on any other aspect of the profession except for the litigation model. So my point of view and my experience is limited to the only model that I have practiced in, which is the litigation model, and that too in Delhi. And I suspect that this happens to be among the busiest of jurisdictions within the country. So I don't know how it works in other places. I just have second-hand knowledge based on what I've discussed with others. So with these boundary conditions and caveats and disclaimers, please feel free to take whatever I have to say with a bag of salt or a pinch of salt as you wish. Then I typically have said this, I think maybe more than once, that if you're interested in a career in litigation, you split the litigation life cycle, or the beginning years or the formative years, at the 3rd year milestone, the 5th year milestone, and the 7th year milestone. The first 3 years are spent trying to make yourself useful to your immediate senior, where you're good at research and drafting, and where you're good at managing the file, where you're good at keeping track of cases, where you're good at understanding the client's expectations, where you may or may not get an opportunity to interact with the client. And the 2 years following that is where you actually make yourself directly useful to the client, subject, of course, to the kind of freedom that you get from your employer. And during that phase, you go beyond research and drafting. You start understanding how the court operates. Your your ability to read the room, your ability to understand how a particular person behaves, your ability to strategize becomes better. The 2 years after that, which is the 6th and the 7th year, is when you actually arrive at a position where the forum, the court itself, takes you seriously. Okay. So the first year is your boss. The first 3 years, your audience, your primary audience is your boss. The next 2 years would be your client. And the 2 years thereafter would be the court itself. By which time, at least by the time you're done with the 5th year, you are expected to know which area of practice you're good at, and what model of practice would you wish to subscribe to, and how do you wish to move up the value chain or remain at the value chain, which is in terms of being a solicitor who sets up either a chamber filing practice or a law firm, or do you wish to become an arguing counsel? These are choices which are partly driven by your skills and partly driven by what the rest of the audience thinks of you. Because you may think the world of yourself, but if the court and the clients don't reciprocate your faith in your abilities, then it may not work, because ultimately this is a two-way street. It's not a solo act. So your faith in your abilities must be reciprocated by those who give you work. When that happens, you get to take some of the decisions that you can with the freedom that you wish to. And once you're done with the first 7-year cycle, the typical approach should be to keep adding further areas of specialization to your repertoire of practice. Otherwise, what happens is that your skills saturate, they normalize. Plus, after a point, the brain's ability to take up new subjects comes down if you don't keep it fresh. And plain and simple, from the perspective of keeping your own journey interesting, it always helps to read or take up new subjects. Now, people might say, if you're known for a certain area of specialization, how do you make the jump or the switch? You don't make a jump or a switch. You try and create an ecosystem of practice areas. So, for instance, if you take up intellectual property, it's better to know competition law, it's better to know arbitration, it's better to have some idea of IP taxation, it's better to have a fair picture of IP contractual disputes, and even constitutional law, because almost every subject is capable of being tied to any other subject depending on the right kind of circumstances. So if you create an ecosystem of practice areas, then it helps from a client perspective as well, because they don't need to go to different kinds of specialists for the same issue. And every transaction is not a pure IP transaction. It has much more than that. So these are, I think, a few points which I could distill from the 14 years that I've spent in the profession. So I open it up for questions. please feel free to ask whatever you wish to. I have only one suggestion, 3 ground rules. One, since the topic is about my journey as a litigator, try to keep the questions as relevant to the topic as possible, because the idea is not to create a YouTube short or an Instagram reel here. The idea is to keep it very, very professional. So stick to the topic. This is to derive the maximum amount of benefit as professionals. That's how I would see it. And 2, introduce yourself so that I know which year you're in and what is the experience that you're coming from. 3, unless and until it's absolutely necessary, try not to bring up issues with respect to my public positions, because again, as I said, it goes back to rule number 1. It's not relevant to the topic.
Excellent, sir. Thank you very much for these opening remarks. You have, in very simple terms, have pictured how an ideal career has to be planned, how the life cycle of a litigator has to be planned, and what are the milestones one can keep when you're looking at your career. I think the outlook will be much clearer for budding practitioners or budding students who are getting into practice. It will be extremely useful. Having said that, I also completely endorse your views, sir, and we have discussed internally that we will not deviate, we will not digress into questions that seem to be popular, but not necessarily centering on the topic. So we will come back to the topic. We will weed out all the questions that are not required to be discussed here.
Right.
There are many other forums to do that. Therefore, we will strictly stick to that. This is an academic forum where we wanted to learn from leaders like you. And the subject here is about the practices, about your own practice here in case, and what lessons we could draw from that. In
Right.
your experience, you have handled several cases, and what are 1 or 2 lessons that we can actually draw from that, listen to you, and distill 1 or 2 takeaways, go home and apply that in our own domain. That is,
Right.
in simple language, summary of what we intend to do. We have done that 139 times so far, and this 140th time also would be so. I'm very thankful to you, sir, for setting the ground rules. It has actually helped me, and we will do, as I mentioned, 2 clusters of Q&A. First one will be led by Professor Prasad. I request Professor Prasad to start. Thank you, Professor Prasad.
Thank you, Professor Rao. Indeed, a pleasure hearing your opening remarks, Deepak Garu. I think I'll come straight to the first question. And this is related to careers and career planning and what happened in your case.
Right.
The question is, what factors have shaped and influenced your personality and career till date? There are a lot of audience around of different types, and something will help somebody.
Okay. So I don't know whether it's good or bad, but I was crystal clear about why I wanted to do law. And I was very clear about what I wanted to do in law. I was very clear about how I wanted to go about it and within what time frame. Okay. Now, some people may have, let's say, a wider vision where they want to dabble in a few things, test the waters, and then take a decision, which is good for them. There's no problem with it. But since I come from a lower middle class family, I did not have the luxury of keeping multiple options for experimentation. I was already experimenting with my life by making the transition from engineering to law. So I had a lot of people to answer. And fortunately, despite initial reluctance, my parents let me go about taking my own decision on this crucial aspect of my life. So I did not want to let them down. And so let's just say I brought the focus of an engineer and the analytical skills of an engineer to law, where I basically said, this is how I would want to go about it. So intellectual property happens to be the subject that I took up because the profession was not at that stage open to absorbing people from the non-humanities background. Okay. So had people been open to taking students or graduates from the engineering background into corporate areas or some other area, perhaps I'd have made that jump. My end goal or destination was always Constitution. That much I was very clear about. But Constitution does not pay the bills in the first few years. If you really want to make sure that you're repaying your education loan on time and you're not a burden on your family, then in my limited headspace, commercial litigation was the only thing that I could take up. So when I was in law school, it so happened that my final semester's internship was at John F. Wells Technology Center in Bangalore, which is GE's second largest R&D center outside of the US. And they have a center called PACE, Patent Analytics and Center of Excellence, where they basically undertake business intelligence and competitive intelligence based on the patent filings of their competitors. So they have a gas turbines division. And as part of that division, I had to go through thousands of patents to basically make sense of all their competitors. What are the areas in which GE could either file patents or operate without infringing, so on and so forth. This is what we were doing. Allow me to say this, I was very good at it, but I was bored to death. Okay. Because I was 100% clear that I did not take up law to do this. I was much more interested in being in court. So despite getting a PPO from them, I did not tell my parents that I got a PPO from GE, because as middle class families, they'd be interested in pushing me into a brand as a company. I was very clear that litigation is where I would be in, because the idea was to go through the rigmarole of litigation, whatever it meant. And if it meant carrying files and going to the registry and whatnot, I was perfectly comfortable with it. Whatever the profession demanded, I was happy to do it. I just saw it as Mata Saraswati, before whom I would do Sashtanga Namaskaram. That's how I went about it. And secondly, because I have an engineering degree, people assumed that I would be comfortable with patents and intellectual property. There are two ways of looking at it. It is a presumption, but it's a rebuttable presumption. Okay. It just so happens that in my case, I certainly think I have an aptitude for intellectual property, but I was never going to limit myself to that. I just decided to use that as a stepping stone ultimately. And I just decided to keep working until such time that the profession was ready to accept me for different areas outside of intellectual property as well. So that is a waiting period that I think you must take. I mean, you must be comfortable with, and you must be patient about, particularly when there is some degree of specialization in the kind of practice that you take up in the initial years. And intellectual property till date is seen as a slightly specialized subject, although I don't, because I see this as part of the broad basket of property and civil commercial areas. I don't see it as being super specialized. It may require certain additional skill sets, but according to me, a lot of other subjects do as well. It's like saying that someone who has done a chartered accountancy must limit himself only to commercial areas and should never venture into criminal practice. That can't be the way it goes. Okay. So I was recommended for constitutional practice by my law school advisor to Mr. Gopal Subramaniam, who had then become the Solicitor General in 2009. So it sent me specifically with a recommendation letter. So Mr. Gopal Subramaniam was kind enough to give me a telephonic interview. We discussed, and it just so happens that perhaps it was the chip on my shoulder of being an engineer as well, or maybe because I had financial commitments to attend to. I basically put out my financial expectations, and he was kind enough to say that although I want you in my chambers, I need to stick to the regime that I have in terms of what I pay my juniors. So that's one of the reasons that I did not take up that option. And in a good way, I think it helped, because commercial litigation prepares you for finer reading. It prepares you for very sharp preparation, which is much more important before you jump into constitutional litigation, because constitutional law has a tendency for broader reading or slightly vague reading. I'm not saying this in a negative sense. I'm just saying that compared to commercial litigation, constitutional law flies a bit higher. Okay, which is good for that subject. But if you really want to sharpen your skills as a litigator, and you want to sharpen your skills as a person who knows how to draft well, how to make sure that what you write and draft pinches the other side, commercial litigation is the testing ground. That's the boot camp. And while I was working or doing my internship at John F. L's Technology Center, I was introduced by Mr. Shamnath Bashir, the late Sri Shamnath Bashir, who used to run Spicy IP, because I used to write for Spicy IP. He put me in touch with Mr. Sai Krishna, who was looking for people who could handle his patent matters. So over weekends during my internship, I would fly down to Delhi from Bangalore, work on their patent matters, prepare the drafts, and I'd go back. So that also opened another line of communication for me as a plan B in case nothing worked out. So when I graduated from law school, I had three options. One was from John F. L's Technology Center. The second was a potential option with Mr. Gopal Subramaniam. And third was an opportunity with Mr. Sai Krishna. Since Mr. Sai Krishna offered, let's say, a certain financial incentive, so to speak, which was commensurate with my expectations then, coupled with the fact that it was commercial litigation and it would be in Delhi. And because it would be intellectual property, it was a confluence of factors. And so I decided to take up that option. And then I continued to add subjects with time. So I think perhaps the summary of what I'm trying to tell you is keep your focus on your goals crystal clear and see how best to use the opportunities that come your way to move towards that goal as much as possible. And as long as you're sure that this is where you wish to reach and this is where you want to go, don't regret taking up a few options. Just make sure that the decisions that you make are by and large geared and oriented towards the goals that you have chosen for yourself. And this is a decision that nobody else can help you with. It's a decision that you have to take, and it's your own journey at the end of the day. So I've said this before, I think it's important for people, especially litigators, to be witness to their own actions. You must be able to look at your decision from a third party's perspective as to whether it makes sense or not. Only then it becomes easier for you to maintain objectivity about your decisions. And you also will be in a much better position to assess whether you're moving forward or backward or are you stagnant. That level of situational awareness, according to me, is very crucial for someone who wants to be a litigator and certainly a good litigator.
Excellent. I think you made it useful for virtually every profession, anyone who wants to get into a career, the beginning path. You have emphasized focus, you have emphasized openness in a certain way, courage that you've shown, interest, which you highlighted about interest, and finally the financial aspect, and not to at all forget the fact that all this involved a lot of hard work.
Right.
Thank you for summarizing it and giving us such a broad view of this.
I'll just add to that point if you don't mind. So in the final semester, it so happened that quite a few law firms, big law firms, had come for campus interviews. And I sat out of placements knowing fully well that I didn't want to be a part of those firms because it did not fit well with my career, let's say, path that I had chosen for myself. And because my CV was good and I was known for my legal blogging skills by then, and my grades were fairly decent. I think I was in the top 3. I was asked by these law firms specifically as to why I did not want to join them. I don't want to name the firm because I still have a very good equation with them. And they called me for a midnight interview at their guest house, asking me my reasons for not joining or not being a part of the placement process. So I said, this is what I wish to do. You tell me where do you fit in my career path. If you can convince me, I will join. They said it's a good thing you're not joining us because neither of us fit the other's career path. So I think if you have that level of clarity, you will also have excellent reasons to say no to what might seem like a good option at that stage. Because a good option is a good option only if it fits your overall goal. Otherwise, you don't test it purely on money or brand. That makes no sense whatsoever. And I've realized that in litigation, there are multiple fantastic opportunities which may not be well known from a brand perspective, but from an experience and exposure perspective, if it fits well with what you want to do, there ends the analysis, according to me. That's very important because I see that people jump on, they latch onto internship opportunities based on brands without asking, what does it do? How does it help me? Will I be lost in the numbers there? Or will I have some degree of exposure? Will people notice me? And will I get the opportunity to take the blame also for my work, not just the credit for what I do? The ability to take responsibility is a very important aspect of a litigator's job, because ultimately it falls on your head one way or the other. And it's a public sport because every decision that you take, the consequence of it is visible to others. So these are important aspects which people should learn during their internship and use their internships to actually further their career goals, as opposed to populating their CVs with brands which may or may not have any value whatsoever to their overall journey. That I think is crucial.
Fantastic. I think in today's age where there are so many more opportunities, what you've said is even more important. And some more points which come out are, I think there's a great degree of self-awareness being shown at that age. Could also see that the clarity has reduced the confusion. Clarity has also built up the courage, inherent courage in your decision making. Thank you very much for adding those points. I move to the second question. This is, though it comes from litigation, it is also useful to many others. How do you prepare to win a case? Some tips which help legal and non-legal professionals in a very competitive world?
So we can prepare to win, but at the end of the day, I don't think there is any other profession where Bhagavad Gita works out so beautifully, because the outcome is not in your hands at all, no matter what you do. Okay, so all you can do is, one, understand that the client's interest is more important than your professional ego. That is sometimes crucial for people. I think practicing lawyers will tell you that sometimes you have to keep yourselves behind and place the client's interest above. Where there is a happy marriage between the client's interest and your professional interest, that's brilliant, that's fantastic. But sometimes you need to know that the cause is bigger, the case is bigger, because they've come to you with the confidence and the faith that you will understand their point of view and that you will do justice to their faith in you. Okay, so that has to be respected first and foremost. Two, maybe it's a cultural thing, or I don't know what it is, but it's important not to oversell the outcome or the possible outcome. Don't make a commitment or, let's say, a promise which you know for a fact is reasonably not possible. So which is why I think client counseling sessions are very crucial. That is an important part of training. So that as part of strategy, you do two things. One, the strategy must be consistent with what is within the realm of possibility. I'm not saying, therefore, don't think wild, don't think radical. Sure, out of the box thinking certainly helps when you know for a fact that conventional thinking has its limits in a given situation. Okay, then you certainly get unconventional. So there's no problem with that at all. But the bottom line, perhaps, which is the undercurrent of the first 2 points, is your ability to be realistic and honest in terms of setting the expectations to the client. In the formative years, perhaps out of a sense of wanting to impress or making your presence felt, there could be a tendency to overcompensate, either in terms of presentation or in terms of a promise. Okay, allow me to say this. I may have overcompensated in the formative years through louder presentation. It has always been clear, it has always been, according to me, systematic, but sometimes the aggression would be unwarranted. Okay, so with time you realize maybe you don't need to be this aggressive. These are aspects that you learn with time. And two, once your position in the fraternity is secure, then automatically the tendency to overcompensate comes down. So I think it's difficult to practice this in the formative years, but I think it's important to be aware of this tendency once in a while. Okay. Three, I think this is one profession where you must realize that two heads are better than one. So if you think this is going to be a solo act where you will constantly be the brightest mind in the room, that cannot be the case. That is not the case. And you must learn to value the strengths of others who have chosen to work with you. And whether you choose to set up practice as a law firm or as an arguing counsel, in neither situation, it is a solo act. It is always a teamwork. It just so happens that when you happen to practice as an arguing counsel, you become the face before the court. But you know for a fact that there are others who have worked with you on the research, on the preparation, on the strategizing, and everybody who helps you save time is contributing to your outcome. So I think that's important to know. From a very, let's say, granular perspective, I owe what I think is my clarity of thought to my belief in writing, heavy writing. And it was also partly because of, let's say, dearth of opportunities. So I am the product of the first batch of my law school. So every first batch goes through a lot of teething troubles. And every first batch has a lot of competition within to see who gets to make their presence felt the most and who gets the maximum amount of opportunities in moot courts or in internships and whatnot. I think every first batch, that is the destiny of every first batch. Okay. But my law school was and remains 120 kilometers away from Calcutta or Kolkata. So the ability to participate in moot courts was limited. And because IIT Kharagpur campus is brilliant, it's beautiful, but it's certainly remote from Kolkata, we had to choose our, let's say, our battles in terms of which competition would we be in a position to participate in whatnot. And every competition would mean travel, would mean additional expenditure, which would be a serious consideration whether you go there or you don't. So I decided to change that approach and I decided to write, because two things would happen. I think conceptual clarity is tested when the pen meets the paper. So that is something that I decided to do. And two, I was fortunate to be given an opportunity to write as part of SPY CIP by the late Sri Shamnath Bashir, Professor Shamnath Bashir. And around that time is when Bajaj TVS litigation was raging. And I didn't know that my very first post on SPY CIP would then be cited by the division bench of the Madras High Court as part of its decision, which was at that time perhaps the first instance of a law student's work being cited by a court. And it became a central part of the judgment of the division bench. If I remember the bench right, it's Justice Ibrahim Khalifullah and Justice Mukhopadhyay. And I think this was delivered on 18th of May 2009 by the division bench of the Madras High Court. And where they set aside the injunction that was granted by the single judge. I think it was Justice Jyotimani. And so writing became crucial, one, out of necessity, and two, I realized the value of it in improving my ability to think. Confusion, I think, is a very beautiful thing because chaos and confusion are processes which lead to clarity. So if you know how to make use of that confusion and start asking the right questions, then the manner in which you start thinking also becomes much, much better. Because once you have multiple, let's say, variables being thrown at you, the brain does take some time to process everything. And it is that processing and that, let's say, that reordering when the processing happens, that actually determines your clarity. So whether it's writing a book or an article or whatnot, there is an extremely painful phase of confusion that you will go through after having read the material, because you'll have about 25 to 30 bullets to fire. And the question will be, which is the best bullet that I pick up to make my point in the best possible manner? Okay. And that you will realize is a crucial aspect of strategizing an argument before a court in later years. So the ability to withstand that confusion and allowing it to affect you is very important, because then your system will start reacting to that confusion in its own way. Okay. So writing has been of immense help, which is why I continue to write. And in the formative years, I think I was very, very particular and particularly harsh on myself, because I used to maintain, and until recently, I maintained a mistakes log, wherein whether my reporting senior would be aware of my mistakes or not, at least I would know where I've screwed up. Okay. So I maintained it for a very long time until I did not have the time to maintain it any further. Not that I don't make any mistakes, but it has become second habit or second nature to keep track of it. So in terms of the larger strategy to win a case, I think it's crucial to realize that you can do only so much. You can do only so much to push your client's point of view. After that, once the arrow has been fired, the ball is no more in your court. Whatever the outcome, you just have to prepare for it and you have to start thinking of the next steps. So the strength of a litigator is not just to prepare for victory, but to quickly pick yourself up in the event of a negative outcome and start discussing and deciding the next steps. So while you finish your arguments, you'll have a broad sense of which way the matter is going. And you'll immediately start recommending plan B to the client. Okay. So the ability to think on your feet and the ability to judge a moment on its own merit and not be stuck in a particular, let's say, ossified phase. These are softer aspects. So some people are born with it. And I believe that these skill sets can be acquired and can be sharpened. Now, whether you are born with it or not is not in your hands, but the profession demands it. So you have no other option but to pick up those skills. So it's a let's call it an occupational imperative in one way. So, which is why I think an understanding of human psychology is very, very crucial to be a successful litigator, because you're reading people, you're reading situations, you're reading the broad patterns. All of that goes into, let's say, it's part of your training. And I genuinely hope that students realize that these are the demands of the profession and they choose and use their internships bearing these requirements in mind. That you will not get a better training ground after that, because once you enter the profession, nobody cares for your career. Only you are interested in your career. Nobody has any reason to think about you, because everybody is running after their own goals. If you can't teach yourself and you can't take yourself seriously, don't expect anybody else to take yourself seriously. If at all anybody has an interest in your career, it's only because they see your career as being valuable to their career. As simple as that. Okay. So that's the incentive model on which this profession works. So if you're serious, enter litigation. If you're not, you'll be chewed out within the first 2 years. And nobody has the time to sit and console you. As simple as that. It's a demanding profession. So I call it the demanding mistress. 100 people want to marry her. She will choose only a handful. So you have to rise up to her standards.
Fantastic. I think your response, though you quoted from your experience as a litigator, is useful to many other professions, which is also extremely competitive and more so in today's world. To quickly run through, I think you emphasized the importance of context in which the client is one, the law is another. So understanding from starting there, understanding the limitations, setting expectations, and then the communication aspect of it, which also you have highlighted, and then being ready for plan B. I think it's extremely clear and it looks like a war situation. And I'm sure there are a lot of other professions also which viewed that way. Thank you very much. There are many other questions and I would like to ask a third question, but I'll pause here and hand it back to Professor Rao.
Thank you very much, Professor Prasad. Sir, it's very interesting listening to you. And for a moment, I thought that, for a moment, I thought and I forgot that we have to ask questions because you speak so well. This is the first time I'm listening to you live. I've heard you many times over YouTube and other channels, but this is the first time live and very interesting. And I have started writing down many things from what you've discussed. I'll take a moment to acknowledge the presence of some very, very distinguished individuals around the screen this evening. A lot of academics have joined, those who are heading law schools, not just at ICFAI, but law schools outside as well. People from the legal profession have joined from India, as well as I can see one or two from UK as well joining. I'm sure we have war veterans also joining, people who have held senior responsibilities in the war, right, who waged wars are here. Students have joined, a couple of students have joined, a couple of young professionals who recently completed their law program, but have gotten into the market, they have come back and joined. I think I want to thank all of them for showing interest in this. A huge number of people have joined both on Zoom as well as on Facebook Live. And they have posed large number of questions, and it is our duty to filter it out given the paucity of time. So what I will do now is I will completely keep myself with the satisfaction of not asking any question. What I will do is I will request them to raise their hand and I'll open the mic for them directly. I don't have to ask any questions. I'll just moderate a little bit here and there. What I see in terms of hands being raised, there are quite a few people who have posed the questions also, but I'll open this thing. But just in case a person is asking a question which is going beyond the rules of the game, what we set for ourselves, I will interfere. And I'm sure Deepak sir is also going to probably correct that. Over to you, Ms. Pragya Singh.
Good evening, sir. Good evening, Deepak sir. My question is that even after serving a lot many years into litigation, can a person enter into a tier 1 law firm?
I think it is possible because you see a lot of law firms certainly look for people who have extensive court litigation. I know of several partners of leading law firms who have been either independent litigators or who have worked with litigating chambers in district courts and high courts for several years before being absorbed as law firm partners or even as managing associates or principal associates. Yes, it is certainly possible. I know for a fact that law firms have started looking at their hiring patterns in a very different way. So when I was an associate partner at Sudhakar Associates, one of the things that I seriously considered was to start creating pure research positions within law firms, wherein people with an academic or a policy bent of mind should also be part of full service law firms or litigation law firms, because I felt that those are brains which are valuable and they should not be relegated exclusively to think tanks. And I have personally benefited from academic research as part of even heavy duty commercial matters. Okay. So I realized that this has started becoming a trend subsequently. And there used to be perhaps a certain filter, both in terms of law schools and taking people only from law schools as freshers. all those walls have broken. Today, the profession is way more open. It's way more, let's say, keen on experimentation. As long as a person presents an interesting opportunity or an interesting profile where there is value in what they have done and they have taken their journey seriously, I don't think the doors are closed anymore.
One more question, sir. If a person is specialized in other fields in law other than corporate law or business law, can a person surely have a good career into firms?
I think that's a very specific question, ma'am, that depends on what kind of firm that you're looking at and what kind of an opportunity you're looking at. The broad answer remains, assuming that there is, how do I put it? See, ultimately, it's a question of the supply side and the demand side meeting each other. If your profile makes sense to the law firm's area of practice or its potential areas of practice, sure, why not? But if that's not the case, I don't see how it works, because ultimately law firms operate much more ruthlessly and much more clinically on economics of scale than, let's say, individual chambers for that matter. They have a lot more, let's say, focus on deliverables and billables. So I'm not in a position to answer your question unless until I know exactly what the situation is. And perhaps this is not the best place to drop names and speak of law firms. So the answer to your question is yes, it certainly happens. I have worked with several such people who have been litigators on their own and then who have joined law firms and who have now started practicing as solicitors through law firms. So that certainly does happen. I hope that answers your question broadly.
Thank you, sir.
Thank
Thanks
you.
for answering.
Thank you very much. Thank you very much. So what this is turning out to be is a very, very useful masterclass in career crafting. I mean, examples from your own career, the way you had maintained clarity right from the campus in the last few semesters, perhaps even before, and your choice of the first job, choice of the internship before that, and the subsequent switches that you have made, I think gravitated towards only one point, that is absolute clarity in building one's career. I think this is one of the finest examples that we can go by. Thank you so much, sir, for being so inspiring.
At one point, maybe that will be useful because it's actually funny. As part of law school, although I was clear about where I wanted to be, I'll tell you how ignorant I was about the legal industry. Since all my friends and all of us came from the engineering background, because IIT Law School is geared for people from the science and the engineering background, our parents thought Khaitan and Khaitan was the name of a fan manufacturing company. Okay, they didn't know that it was the name of a law firm. Okay, when somebody mentioned Amarchal Mangaldas, I thought this was the name of a matrimonial website. Okay, I had no knowledge of it at all whatsoever. Okay, this is how bad it was. And my typical mind was, the success in the legal profession was, success in legal profession means being part of a company. Okay, that's how even I was trained to think in the first 2 semesters. Fortunately, I quickly learned in the following 4 semesters, and mine is not even let's say 5-year program with 10 semesters. I had exactly 6 semesters, and 6 semesters just fly. So it's very difficult for you to consistently have, let's say, a string of internships which teach you a lot. So that is the level of ignorance with which I operated. I have no problem sharing that all because I'm a first generation lawyer, so I had no idea whatsoever. But I think I learned fairly quickly. And 2, I think this may be useful to your students. Internships I've seen are increasingly becoming subject of some kind of LinkedIn posts where people see that as an achievement in themselves. I'd say don't set the bar so low where gaining an internship or doing an internship becomes a mark of your achievement. Maybe there is a tendency to make your presence felt through these kind of, let's say, announcements or updates on LinkedIn. Trust me when I say this, the legal profession and certainly litigation is a marathon. It's not a 100-meter sprint or dash. So you have to give it some time for it to start showing rewards or start showing some results. Be impatient, no problem, because it is impatience that keeps you alive and that makes sure that you're constantly running in a particular direction. But also realize that this profession works at a pace which is different from your pace. In the initial years, you may want to run. It makes you walk. And if you consistently walk, it then starts running at a pace where you will be expected to keep up with its pace. Okay. So it's like a treadmill which picks up pace at a slow pace. And then if you don't keep up with the pace of the treadmill, it will throw you out, period. So just wait for the profession to tell you that you're in the right place. Until then, be patient is all I have to say.
Amazing, sir. Amazing inputs for those who are keen on building their careers. The ability to think clear and also ability to think on feet is a very, very big input. And it is imperative that this career is highly, highly demanding, and only those who constantly learn, only those who constantly try to invent and move forward and make sure that the investment, they stay invested in this career, are the ones who stay benefited. Thank you so much, sir. I'll request Mr. Venkata Subramaniam to raise this question.
Good evening, everyone. I'm S.V. Subramaniam. Two questions. So one is the first one is, why law is so complicated in India compared to other countries' situation? And there are at least 100, 150 legal luminaries names we see in papers on almost on a daily basis, who have got 40 years, 50 years, 60 years experience, still attending to court. Has any of them tried to simplify the law so that a common people can easily walk into the court or can easily deal with it? That is the first question. Of course, so many legal luminaries, they are into politics also, but has anybody tried? The second question is, this in this profession, what I understand, what I was also under the impression, the second generation or third generation advocates, the students, will have advantage, will have a leverage over the first generation guy like you. So is it true? So these two are my questions.
I'll start with the second question, and that'll also give you some idea about the first question. So yes, there is some advantage that comes with pedigree, but I think it was Dr. Singhvi who said this in one of his oldest interviews with Rainmaker, if I remember it right, where he said that pedigree is rebuttable presumption, because you may be the son of a great lawyer and it may be expected of you that you too are a great lawyer, but time will show whether that presumption is valid or not. Okay. What is different between a first generation lawyer and someone who comes with at least a second generation under his belt is this: the softer aspects of the profession, people like me have had to learn the hard way on their own. Okay. In terms of how to meet people, how to greet people, how to make clients, what to say, what not to say. These are aspects that we have learned on our own, which is something that they are groomed in already. Second, obviously, there's a vast network that, or at least there's a decent network that a second generation lawyer can tap into. From a very concrete perspective or a very tangible perspective, setting up a legal office and setting up a legal library are not cheap. They're fairly expensive. So you get access to those resources as well. Four, trust me when I say this, when a first generation litigator performs well, it draws more attention than someone who is a second generation litigator or a third generation litigator. Because if you come from a generational legacy, some things are expected of you. But if you don't come from a generational legacy and you happen to do well, it makes a lot more people sit up and take notice of your presence. So that too is equally important. Sometimes legacy can be a liability for those who are beneficiaries of it. And there are very popular examples. So I think there are pros and cons. The question that I think which is more important is not whether they have advantages or not. They certainly have advantages. The question is whether there is place in the profession for first generation lawyers. Can they do well? That is more important to ask than whether somebody else has an advantage. And in a country like India, everybody has some advantage or the other thanks to connections. So I don't think it's just having a father or an uncle or a relative in the profession that makes for an advantage. My experience of Delhi, and I don't know how it works in other places, is that I'm extremely proud of being let's say, a product of the Delhi bar. I think Delhi is perhaps the most open bar for any young first generation litigator to be a part of. It welcomes people and youngsters as long as they are good in their subject. Those who are committed to the profession are given a fantastic treatment here. The tradition, at least of the Delhi High Court, has been that young lawyers are encouraged to argue. And I'm not sure if given the same number of years, I could have done as well as I've done in Delhi in any other court. I'm not painting a negative picture of any other place, but Delhi in that sense has been very, very cosmopolitan and open. And I genuinely hope that this is the culture in the rest of the courts of the country. or at least it must become the culture in other courts, if we truly want youngsters to join litigation and make a difference to the evolution of the subject and also to the speed with which we dispose of matters. So that is the answer to your first question. As far as the second question is concerned, sir, no practicing lawyer has any interest or incentive to simplify the law. Okay. That is for the Ministry of Law and Justice to address through bureaucrats. Second, what most non-lawyers don't realize or understand is to be able to interpret the law is not the same as having the ability to draft legislation. These are two very different skill sets. Legislative drafting is a separate skill set altogether. So I can perhaps be fantastic at interpreting a provision. I can perhaps even offer certain suggestions. But do I have the skill sets to put together a legislation from scratch on my own? Dare I say, I perhaps may not have the skill set because that requires a different kind of training altogether. Okay. So I understand that this question is important from a public interest perspective, but litigators operate on a case-to-case basis, on a subject basis. The question of the bigger picture is for the government to address. So how a law is drafted, how easily it's drafted, how lucidly it's drafted, and how simply it is drafted for people's consumption, that is a question that must be posed to others. You cannot expect practicing litigators to take up this job. One, because their goals are different, and two, the skill sets are different. So usually, I think I've heard two questions come from most, let's say, non-lawyers to the profession. One, why aren't laws simpler? And two, why do our courts have so many vacations? I've heard these questions so many times. I don't think they understand the realities of being a judge in an Indian court or even being part of the judiciary. Take this from me, and I say this in a very conservative way. Even if 5 to 6% of the Indian population chooses to go to court, our system will crumble simply because of the sheer numbers at play. And two, as a lawyer, I have very little incentive to go to the other side simply because there are severe limitations on how much a judge of a high court or a Supreme Court can make, because they can never make more than the President of India under any circumstances. And what the President of India makes in a given year, most law firm partners make more than that, sir. You put all the perks put together. So if you're used to a certain lifestyle and you're in this particular profession for a certain reason, you don't expect all of us to serve public interest, because it's not as if all of the professions are serving public interest. So those expectations need not be foisted on the legal profession. We too are individuals. We are also equally entitled to have lifestyle expectations of our own. So not all of us are in the business of public interest litigation or constitutional litigation. We are hardcore commercial litigators for a reason, because we too have an interest in making a livelihood out of it. Okay. So I think these questions must be directed to bureaucrats and to the state, and not to practicing commercial litigators. We will certainly give suggestions if you're asked how to make something simple, but the job of drafting something is in the realm of the government.
Thank you, sir. Thank you very much. And the detailed answer, and pretty sharp and pretty JST types.
Okay.
Thank you. Dr. Akbar Khan, can you take the question? Yeah.
Yes, sir. Good evening, sir.
Good evening.
Sir, it was really scintillating to hear you out, sir.
Thank
Myself, Professor Khan. Yeah, I've been in association with ICFAI for the past 17 years, sir.
you.
My question is, what are the factors, sir, responsible for the diminishing level of morality or ethics in the profession? Or shall we say that morality has changed, or is it being redefined in the profession?
I think it is being redefined in the profession, and I don't think it has fallen or gone up. We are actually reassessing what it means to be honest in this profession. Okay. See, I'll put it slightly differently. There was a time when perhaps in the 80s and early 90s or even early 2000s, the legal profession was not the go-to profession for people who are interested in not getting into trouble, people who are interested in leading relatively cleaner and straightforward lives. That would also reflect in the quality of people who would take up law as a choice of career. At least in Hyderabad, which is where I come from, you don't take up law unless and until you have failed in mathematics, you have not been able to secure something in engineering, medicine. That was the situation in my generation. I don't think that's the situation anymore. Now it has come to a point where some of the finest minds, including those who could have taken up, let's say, engineering in the best of institutions, are choosing to take up law. That tells me that we are looking at a certain phase in the legal profession in Bharat, where the average, let's say, IQ of the person or the average talent of the person who's opting for law as a choice of career is going up. Okay.
Right.
And a significant reason for this could also be the streamlining of the profession through the setting up of national law schools. Okay. That is perhaps one reason. But the other reason also is ever since our economy has been liberalized, it has presented greater business opportunities, more business models, and more contractual disputes and greater expectation from investors to ensure that the judiciary is both sophisticated and speedy and sensitive to their needs. And which is one of the reasons that ease of business rankings have, let's say, judicial outcomes as one of their factors or one of their indices. That tells me that right now we are going through a phase where it is attracting talent. And therefore, when fresh talent and fresh minds enter the profession, automatically it means that there's going to be a greater churn in what are the values we must subscribe to. 3, I think the increasing quality of legal reportage, pure and simple legal portals which are actually tracking our cases and developments and outcomes, also makes it imperative for us to conduct ourselves better because people are watching in multiple ways.
Right.
So I would think, sir, that we are going through a phase of transition. Now, which way the transition would go would also depend on which way the society goes, because after all, we are also part of the society. If overall standards of morality and ethics go down across the board, we can't be exceptions. And if overall standards improve, hopefully we will not be exceptions to that rule. So that's how I would see it.
Can we conclude that it is the society is in transition, and have we reached the stage of anomy? Anomy, as Durkheim has said, actually, where we are totally undecided as to what is to be done next or what is to be decided or how wrong and right to be differentiated. Is it a state of anomy then?
I would certainly think so, because I'll tell you why. When a society which has suffered artificial poverty by imposing fetters on itself suddenly starts seeing money, then the first goal would be to earn money. Okay. So until 90s, for close to 40 years, you repressed yourself through a license permit Raj. And once you suddenly opened up the economy, those opportunities explode. And when that happens, I think for a while, at least for a brief period, values are in animated suspension because people are busy earning money. Okay.
Right.
And then they'll calm down a bit. They'll calm down a bit and then they'll say, okay, let's take a look at how we operate. Don't we have any set of moral frameworks to be guided by? I think a more real life and closer example could be how people started traveling with vengeance after the lockdown, without any, let's say, respect for what it would do to environment. Thousands and lakhs of people visiting geographically or environmentally sensitive areas without a thought being paid to what happens to nature there or environmental balance there. Then people gradually started understanding once they started seeing the impact of it in Uttarakhand and other places. I'm giving a very crude example. All I'm trying to say is that when you repress economically and you suddenly open up the gates, people have a tendency to make the most of it because they don't know how long it will be open. Now that they know that this is the default state of affairs, we will have more and more people thinking with conscience and realizing that we also have to operate with a certain degree of social conscience. So we are in a state of flux. It'll take some time before we settle down.
Right. Thank you, sir. Thank you.
Thank you very much, sir. I think you have taken a good amount of time to convince and satisfy the person who is asking the question. Thank you so much, sir. We'll quickly move to the next person. I'll request Sarwani Curry to ask the question.
Good evening, sir. I'm Sarwani here. So I'm a second year law student from ICFAI, Hyderabad. And my question is, sir, we have the law students will have the legal knowledge, and putting that into the practice after the 5 years is completely different.
Right.
So what do you suggest us to prepare our minds and put our legal knowledge like to keep properly in a practice way? So how do we make up our minds to set for this? Or we have to do this in our internship level, like in internships, we have to make it this up, or after our 5 years?
So I would actually, you've answered the question yourself. Internships are the only window into the real world for you. Okay. One is having visiting faculty who can tell you what are the demands of the industry. My larger criticism of the Indian, let's say, legal education has been the limitation on teachers to not practice. Okay. I think that limitation needs to go. Practitioners must have some minimum obligation to teach, and teachers must have the ability to practice. It's a two-way street. once you do that, the delta or the gap between academia and industry will reduce significantly. But until that ideal day arises, I mean, let's say comes about or comes to pass, I think the option is to fall back on internships. I cannot stress enough on the importance of choosing right internships and making the most of it. I see a lot of people taking up internships for the sake of visibility as opposed to treating that as part of a necessary learning curve. Okay. You have the, let's say, the luxury of making mistakes in these 5 years. You won't get the ability to make those mistakes again. The stakes get very, very high the moment you enter the profession. I'm not trying to dissuade people from joining litigation. All I'm saying is the higher the sense of awareness, the faster is the learning curve, and greater is your ability to watch out for mistakes. You will still make mistakes, but hopefully the quality of mistakes will be better and you will not repeat the same mistake. Okay. So please, I repeat, internships are very crucial. Choose them wisely, make the most of them. And if let's say in a 10 semester program, even if you have 6 decent internships where you're able to string a path out of itself and you know, why did I choose this? How does it make sense to my overall career? How did I go about doing this? Then I think you're getting ready for the seriousness of the profession itself.
So even like internships, we have to like we can jump onto the other topics. Like we don't know what we have to choose. Like in the second year itself, we didn't make what is our goal. Like we are still making up on it. So jumping onto the other topics in this semester-wise internships is better, or sticking to a perfect goal. Like after 5 years, what should I do? And moving to that one path is perfect.
See, I'm not asking you to be hyper calculative. Perhaps what you can do is, here's what I would do if I were part of a 5-year program. If I had joined a 5-year law school, this is what I would have done. Maybe the first 2 or 3 internships would be in academic institutions, NGOs,
Yes.
okay, and get a sense of, let's say, the rougher side of life before I start getting into the practice areas. From the 3rd year onwards, that would be what, the 5th semester onwards, I would seriously start deciding whether I want to be in litigation or transaction.
Yes.
And if I know that this is the area of litigation that I wish to be a part of, then the last 3 internships would be spent doing, let's say, dirtying my hands in that area in different places. So what I'm perhaps trying to say is, maybe first 2 internships can be experimental. The last 3 internships must be absolutely, they must mean business and they must be hyper-focused. Okay.
Yes.
And if you can, that means if you manage at least 5 decent internships, you get to experiment and you also get to work towards your goal. Okay. I say that as someone who didn't know how to go about his internships when I was in law school. Okay. I was fortunate enough to intern at IIM Ahmedabad once and at John Fels Technology Center. I did not have a serious litigation internship as part of my law school. And I say this without any sense of shame. I did not even have the knowledge to know what is a quality litigation internship. Okay. And perhaps I would have turned out better or differently had I got one more internship. But the point is, at that stage, I did not even know what I was losing out on. Imagine the levels of ignorance then. Okay. That I don't think is the case with any 5-year program. So make sure that you have quality 5 internships to show out of a 10 semester program. That's a decent, let's say, number to show for. The last 3 internships must be consistent with the career goals that you have decided for yourself.
Yes.
I'll request Mr. Uday Wagre to raise his question.
Namaste, Sai Deepak ji, and happy Mahashivratri to everybody.
Thank you, Degaru. How are you? I hope all is well.
All is well, God's grace. So I'm slightly on the defensive straight away, hearing about the genie and the lack of time. But
Right.
my concern is, it's more of a concern. There's an almost all-pervasive cynicism towards the courts as an abode of delivering justice.
Mm-hmm.
It used to be said during the earlier times that the judgment is either based on facts or law. That's what I heard my grandfather say when I was growing up in his court, in his office. But later on, as things progress, and my exposure to the system per se didn't confirm to either.
Right.
It confirmed more to the interpretation of the law or the facts or the misrepresentation. So what happens to the common man who's completely unaware of the system, who would go to the court as a final resort of justice, putting all his life savings and the trust, and then he gets a short shrift there. I'm also talking from the personal experience of handling a case in Supreme Court, our own tenancy case, where the two bench judge was Mohan and Mukherjee, and Mr. Venugopal was the attorney. I had personally shifted the case from, I shouldn't be taking the name, but his son is an MP now.
It's best you don't take names.
Yeah. So and then the concern is, when I go to the court platform of delivering final justice, and I don't know where I'm heading, where do I stand in that aspect?
I understand. See, the point is the general problem that most of us face, whether either as litigators or litigants, is the crowding of the system. And you have to realize that when the Madurai bench of the Madras High Court was set up, the building was fantastic, everything was there, but they did not have enough people to populate the benches with. Okay. And this is the situation in a lot of places. I personally believe that if you're looking at greater delivery or faster delivery of outcomes from our system, two things must be done at the very least. I think that expenditure on the legal system must be divorced from the Consolidated Fund of India, and you must look at it as a separate investment altogether. Okay. Because in a profession where remuneration is fairly high, what is the incentive for an above average lawyer to become a judge? Okay. I suspect that the Chief Justice of the Singapore Supreme Court makes much more than the President of India. I did not deliberately compare our positions with the United States or anybody else. I'm comparing it with a Singapore. Okay. So my comparisons are fairly realistic in this regard. Or even in Israel or a Germany or a Japan. If you can match even European nations in terms of remuneration, then there is some incentive for, let's say, pure talent to enter the other side. I'm not saying that now it is not, but those who are doing it out of a sense of service, not because they're going to be compensated. Every person who has to make the transition from being a lawyer to a judge is taking a serious cut on his revenue and his ability to maintain the very same lifestyle. That is a fact. Okay. And if that is a fact at the level of the High Court and the Supreme Court, imagine what must be the case in district courts and other places, or even in municipal courts. Okay. So I think we must seriously hit the reset button, think of ways of incentivizing the legal profession from the judicial perspective. Two, I think for quite some time, people like me and others have said that the Supreme Court must stop becoming a court of appeal and should primarily be a constitutional court. And you must evolve another court in the nature of a Federal Circuit Court of Appeals in the US, where from the High Court, you get to go to that place as opposed to jumping to the Supreme Court. Unless and until there is a certificate that is issued by the Court of Appeals to say that an important legal question has arisen, which requires resolution by the Supreme Court, people should not be able to use Article 136 so frequently and as a trigger-happy option to come to the Supreme Court. In any case, you think you're going to the Supreme Court hoping for a change of verdict, but the pace at which matters are crowded there and clogged there, you don't get, let's say, enough window of an audience to make your point. A matter is decided, its fate is typically decided in the first 5 minutes, and 5 minutes is on the outer limit. It's usually the first 30 seconds or 2 minutes. Okay. So these are certain nuts and bolts issue. Three, in a country like India, despite, or let's say, even if we choose to invest heavily in the judiciary in terms of ramping up its infrastructure, human resources, research resources and whatnot, I think it's very important to evolve certain community resolution mechanisms, because we can't afford to have everybody go to court, and not everybody can afford to go to court. Okay. So as part of, let's say, local self-government, it's equally important to have alternative dispute resolution mechanisms incorporated as part of local self-government, so that you don't expect people from the villages and the districts to knock the doors of the court all the time. And as long as the primary language of transaction happens to be English, it is a daunting task for everybody to go to court. Not everybody can do that. Even if, let's say, a lot of these courts function in, let's say, in the local language, going to court itself creates a psychological barrier in people's heads. So either they go there reluctantly, or they suffer the consequences of not going to court. These are fundamental issues with the legal system in Bharat. And I genuinely hope that the Ministry of Law and Justice works on these aspects. You need to make the legal system responsive to at least three different, let's say, segments of litigation. One is high-end commercial litigation that is important to attract investment. Second is constitutional litigation because that addresses important questions of law of constitutional significance. Third is access to justice for people who come from non-sophisticated backgrounds and who go there for resolution of their disputes, even if they're not high-stakes commercial. These are the three different kinds of audience that I think we need to be able to cater to. And I don't think we are catering satisfactorily to either of them at this stage. We may have made incremental, let's say, improvements on the commercial side, but I don't think we have made incremental improvements on the constitutional side or on the public interest side. Those are certainly genuine considerations, and I agree with the sentiment of your question.
Thank you, sir. Thank you so much. That's quite elaborate. Thank you so much. We'll quickly request Mr. Shiva to raise his question. Mr. Shiva is not there. Then we'll request. Yes, Mr. Shiva.
I'm a non-lawyer, as you originally called. So pardon me if I'm asking you a very simplistic question. I'm asking this primarily from the point of view of me being a teacher, and I've faced a generation of students, and I'm seeing a change generationally, although it is not what we call in terms of the millennials or the Gen Z or whatever.
Right.
Yeah, also interesting because you talked about how you developed your thinking and clarity by writing down.
Right.
Current generations, they write down only when they're forced. And what they write down is always, pardon the expression, a bunch of crap. And they know that they'll get away with writing that. They're only doing it under force. They don't write it on their own because they fundamentally don't believe in anything that they're doing, because it's everything, as you said, has become extremely commercialized. Everything is commercial. Everyone wants to make money. Okay, nobody thinks about how will I make money and what will happen to me if I take the wrong path. Therefore, and that's why I posted that question in the chat box saying, when you take up a case, somebody comes to you, now in the first whatever amount of time that is available, you have to make up your mind whether this is a case worth taking up.
Right.
What if you take up a case and then you decide that this case is the wrong case, I should not have picked it up for a variety of reasons. So the easy way, I thought, was if you have some inkling of the truth in a given situation, then pick it up, because you're supposed to be upholding the law, which means the truth. But are these two separate? How do you decide in a given situation whether this is something I should take up or not take up? Because you represent the truth, not the law is a means to getting to the truth, isn't it?
No, sir, I don't represent the truth when I take up a case, sir.
Because you're commercial.
100% yes. I am interested in making a point under the law. I am not interested in truth and justice when I take up a commercial matter.
Okay, but would you go on record to say that?
Yes,
then no clients will come to you.
No, that's not the point. See, you have to understand this. The point is, the purpose of commercial litigation is not truth. The purpose of commercial litigation is to make your point within the law. And I'm making a point which is perfectly consistent with legal ethics. The first thing that you're taught as part of legal ethics is not to conflate it with morality. Okay. So I'm making a very clear statement that if I can justify a certain position within the four corners of the law, then that is what is expected of me as a litigator to establish. Okay. So the point is, if you decide to go down the path of truth, each party thinks that they represent the true position. So as Justice Midha rightly said on the eve of his departure, or I think, I don't know whether it was, yes, his farewell speech, that both parties present their own versions of the story. It is the judge who is on trial ultimately, because he has to look for the truth between two versions of the story. Okay. I am not saying that I will necessarily represent something that is blatantly untrue, but the very problem with the framing of your question is that we are not interested in looking for truth or untruth. We are looking at legality and illegality and whether it can be legally justified. There are several instances where the truth and legality they coincide, they overlap, but they need not always. And I'm not saying that is controversial. I'm not saying anything that is controversial or even illegal for that matter. See, what am I expected to do? If there is a certain provision, I am expected to pitch my case within the four corners of the provision to say, Either I attract it because it is beneficial or I don't because it is not beneficial. Okay. Now, in doing so, I try to present the best version of the story based on the facts that I have. Now, nobody is actually going to look for truth here as a litigator. We are going to say, we don't attract this or we attract this. Now, whether this results in the truth or not is for the court to look into. Now, what we do is that we look for legal viability to say whether this case will stand on its own 2 feet when I choose to present it before a court of law. So perhaps the fundamental, let's say, gulf between your position and my position is that you're equating law with the truth. I'm saying that need not be the case. It may be, but it need not be as well. Now, there was another part of your question. What was that question, sir? One was this. What was the other question?
Yeah, so I was saying that therefore, if the clients come to you assuming that these two are equal.
Got it. So the other part also of your question was whether it's whether the profession has become highly commercial and all that. Allow me to say this, even if you want to be commercially successful, it is in your interest to actually focus on what is going on in law school. Because if you think that you can simply while away your time here and then somehow wheel and deal once you get into the profession, well, then you have decided that all you're good for is wheeling and dealing and not for actual legal acumen. Okay. If you really want to do well, even commercially, it is absolutely imperative that you take these 5 years very, very seriously. And that means knowing what it takes to present a case well. I'm not saying be untrue. I'm not saying be unfair. I'm not saying be blithe to the concept of justice whatsoever. As someone who takes up pro bono matters on constitutional issues and seriously sensitive issues, I'm the last person to say truth and justice don't matter. I'm saying the definition of truth is different in the context of commercial litigation. And the definition of truth is different in the context of criminal litigation. The definition of truth is different in the context of constitutional litigation. So the one thing that practice teaches you is to never ask a question independent of the context. Okay. And every question must be answered in the backdrop of a specific context. So usually what we do before we take up a case is to assess it on legal merits and to ask whether the material on the record supports your position or not. There have been any number of instances where I have personally advised, because solicitors usually get the clients to ask whether this case has the ability to fly before a court. The job of an arguing counsel is to say, if you were to ask me to argue this particular position in a court of law, these are my problems. These are the questions that are bound to come from the court. These are the issues which I think, let's say, betray or display the weakness of the case. And we have advised clients to settle the matter or close the matter or not pursue the matter. So a successful litigator is not necessarily someone who constantly takes his client to court and promises him success all the time. If you're able to tell the client, cut your losses, this is the best possible outcome, settle right now, this is not worth fighting any further in court. I know the number of times I have benefited from this kind of an advice because clients have been grateful for not leading them down a wild goose chase. Okay. So as an officer of the court, let's say my first priority is to represent my client's position in the best possible manner, which equally means if settling is in his is to his benefit and fighting the matter is to his detriment, that equally is an advice that I must give. So as a practicing litigator, I would suggest law may or may not be equal to truth. Let's qualify that question on the basis of the context. If you wish to be a public interest litigator who's fighting for truth and justice, great. Even that is fine with me. I don't have a problem with it. But if you're asking this question to a commercial litigator, then the answer will be very nuanced. It may even be mercenary and clinical. It will certainly not be ideal.
Excellent. Excellent, sir. I think this is a beautiful answer. The beauty also lies in the fact that some of these important points can be used in management consultancy and probably in other domains as well. If you have a problem-solving mindset, I think you will go down the path of actually disassociating the transactional involvements with the simplicity of an outcome, in the sense that you're again keeping your client in the forefront, as simple as that. And it connects the dots with what you spoke probably 30 minutes back. Wonderful. Wonderful, sir. Request Mr. Subhash from London to raise his question.
Good evening, sir. I'm from UK. In light of litigators adopting no win, no fee model similar to the those in the UK. Do you believe India needs structural regulations to ensure fairness and protect clients, or do such arrangements enhance access to justice?
They may also, because I've seen a lot of contingent fee-based arrangements in other jurisdictions. It is, to the best of my knowledge, it's not permissible in Bharat. You can't do that because I don't think our law allows for it. But you see, you have to realize another thing. It works in those jurisdictions where otherwise access to justice is fairly expensive. Let's not forget that. Whether it's UK or United States, access to justice is fairly expensive if you're looking at commercial litigation. Okay. In those situations, they take a fairly clear assessment of what is the possible outcome. And once the outcome is clear, or once you succeed, they take a significant portion from the outcome based on, let's say, a profit sharing model. I know this for a fact because I happen to work with a German law firm for an Indian client in a litigation in the District Court of Hanover. And we had to go through at least 6 to 7 months of rigorous assessment to convince that law firm in the first place that this is a matter worth taking up on a contingency fee basis. And despite having accepted that they could take up the matter on a contingency fee basis, certain deposits had to be made, which were also significantly huge. And the matter couldn't couldn't last in the court for more than, let's say, 2 to 3 weeks, because we were fighting against a German major in a territory of its own jurisdiction before its own home court, so to speak. And as an Indian party, we were struggling to actually reach out to the German court in terms of putting forth a point of view. It was a copyright infringement case. So I don't think we can think of the no-win, no-fee model as a viable model in this jurisdiction without taking into account the margins of expenses and the margins of, let's say, legal costs in general. If you were to allow me to charge what I would charge in US, I'd say, okay, fine, I'll do it. But you can't say charge Indian rates, but based on a US model. That would be having the cake and eating it too. That can't work. So because as professionals, we also have to look at what is my incentive to continue working on a matter. The standard model, which works for most people here, is that at the very least, you have a clear-cut schedule of fees, and you have fees which are not on hourly rates. So I charge differently for Indian clients and I charge differently for American clients or foreign clients, depending on their ability to pay. But there is a certain level beneath which I will not go, because it represents my standard, it represents my standing in the profession, and I don't wish to be accessible to everybody under the sun because I am not a public interest litigator. So a fee schedule, so to speak, is also your way of filtering out those people who may not be worthy of your time. That's a decision that you're entitled to take in the interest of your professional standing. So the spirit of your suggestion is acceptable, provided there's an ecosystem change. You can't have isolated changes being made to the system.
Brilliant, sir. Good to know about your mindset on that. Thank you. Can we request Srikar to raise his question? Over to you, Srikar. Or we'll listen to Akash, if Akash is ready.
Hello, good evening, sir. I think it's very nice to meet you, and I'm also feeling very lucky to meet you. Actually, I'm following you from past many years, so a little bit feeling also honored.
Thank you.
So, sir, as the topic going on, Mani raised the question about courts and also its pendencies, and you have also giving a wonderful explanation. But as you have highlighted about the salary related to the courts and their situations, but I think, sir, is that thing only the matter? Like if we come to the at Indian level, first I think is the infrastructures, court and pendencies, and if we look at into this, I'll just give a situations. Actually, I had last year a visit to the Kasoli court. It's in Himachal Pradesh, a very small court. But the thing is that I think, sir, the problem may be there is no replacement or there is no alternative. I think because he was a judge of a small court. And as he was saying us that he have to deal with more than 1,000 plus cases in a month, which I think, sir, as I am also I'm currently pursuing my degree, but I think at my level, if I compare to that thing, it's a lot of much. And also, if we look into that area from my hometown where I come, it's a very small hometown, not even that population. We have a small civil judicial magistrate first class court, although the cases are very low. I think last time when I had internship there, it may be 25 cases a day or sometime only 5 to 10 cases. But the problem is sometime judges on you can say holiday now for current she was a lady judge having a maternity leave, so there is no replacement for that.
Right.
The people have to go. It may be not much distance for the people in living in plain area, but for hilly areas, even 40 kilometers is so much. And the main court where we go is more than 70 to 80 kilometer away. So I think, sir, is only the fees matters that, because if we look onto another matters, like you have said about at social at small level, which you say communities. We have example also like Haryana and Gujarat, their panchayat. But as panchayat should be only limited to the civil matters.
Right.
It can be cross. I have also further question, but I like to have a thoughts on it as you can give.
So you're correct that the scale of the problem is not the same everywhere. So I know for a fact that in Uttarakhand, the High Court obviously is not as busy as the High Court of Delhi. Okay. Or the High Court of, let's say, Madras or any other place for that matter. I agree with you. The one common problem, perhaps, regardless of the geography, is that if you look at other countries, one thing is provided by way of support system for judges, is that they are given excellent research and support staff. Okay. From law researchers to people who can actually assist them significantly. From my understanding of even the Delhi High Court, which is supposed to be fairly sophisticated in its approach to commercial matters, the support staff, especially on the research side, are not adequate even for judges in the Delhi High Court. And only a few years ago, I think maybe half a decade or 7 years ago, the Supreme Court set up a separate research office to assist Supreme Court judges on matters of constitutional importance. So perhaps one broad suggestion that we can consider doing is, apart from looking at the pay scales and whatnot, the support system that a judge needs to be able to focus on delivering judgments on time. Can we improve that? That is one question that you must certainly ask. Two, the constant, you spoke of maternity leave. I'll tell you something which is even more common, and I don't think maternity leave is that much of an issue. The problem is that when judges keep changing either their benches, their rosters, or they get transferred out, then we don't have a system of addressing those matters that were pending before them. Then those matters have to be reheard by the person who becomes the successor judge. In the process, all the money that was spent in fielding lawyers before the predecessor judge in multiple hearings have gone completely waste. That money has gone waste. And this, if it happens to be expensive even for people with deep pockets and corporations, imagine the condition of let's say, the average citizen who goes to court. So one is the movement of judges. Can we do something about, let's say, making it easier for litigants to expect outcomes while the person is still on the bench or before they go out to another place? Two, I don't think there is an excuse for lack of delivery in those courts which are as busy. There, I don't see the point in making an excuse whatsoever. If, let's say, the pace with which cases are filed or instituted in other courts or other high courts are concerned, they're not as comparable to the Delhi High Court. I don't see why we can't have, let's say, clearer outcomes. I'll give you a simple example. Over the last 2 years, I've been going to the Himachal Pradesh High Court on a regular basis. And Himachal Pradesh High Court does not have a particular history of IP litigation, for that matter, because most of the litigation that it deals with are either public interest litigations or quarrying or mining related litigations, because that's the business that thrives in a place like Himachal Pradesh. We had an IP matter on the pharmaceutical front before the commercial bench of the Himachal Pradesh High Court. I was astounded at the pace with which those matters were heard, because we completed hearings in 3 to 4 dates, on 3 to 4 dates. The same matter, because of the huge number of matters which are filed in the Delhi High Court, would have taken at least 3 to 4 months for arguments to be completed and concluded. So those courts which are not as busy and which are not as clogged certainly can do better, is my suggestion. I don't think there is any excuse that needs to be offered on that front. I agree with you on that.
Request speaker to raise his question.
Yes, sir. Good evening, sir. My name is Sudhakar, second year ICFAI Law School.
Yeah. Please.
So what advice would you offer to law students aspiring to pursue a career in litigation in India, considering the current legal landscape and future prospectus? With connection to that, can you also share a memorable case from your practice that had a significant impact on your understanding of litigation in India? Thank you, sir.
See, the first question I think I've broadly answered. That's been the sum and substance of the entire interaction, so to speak. So I don't wish to repeat that. But in terms of any example that has taught me a lot, I think I had a fantastic outing in Tata Sons versus Greenpeace, where for the first time we were able to present arguments with respect to interplay between intellectual property rights and constitutional law. If my memory serves me right, this judgment was delivered on the 28th of January 2011 by Justice Ravindra Bhatt, who was on the original side of the Delhi High Court then. And I was second chair, and Mr. Sai Krishna Rajgopal was the lead counsel in the matter on behalf of Greenpeace. Tata Sons was then represented by Sri Rohington Nariman. And before Sri Rohington Nariman entered the picture, I think it was Sri Justice Bobde's brother who was the first counsel, and he was then followed by Mr. Nariman. So it was a fantastic experience because Mr. Nariman is a tigerish counsel, fairly aggressive with encyclopedic knowledge. And on this side, it was Mr. Sai Krishna and myself. This was a case where Tata Sons had sued Greenpeace for defamation and for trademark infringement because Greenpeace had launched a campaign called Tata versus Turtle in the form of a Pac-Man sort of game using the Tata logo, where the Tata logo was designed like a demon which was eating the olive ridley turtles of Odisha. Okay, because olive ridley turtles are endangered species, and the construction of the Dhamra port, according to Greenpeace, was dangerous and catastrophic for the nesting grounds of the olive ridley turtles there. So this was the case, and it gave us a fantastic insight into how different areas of law collide. And this judgment then went on to be cited in several other jurisdictions on how does intellectual property occupy a space within the larger, let's say, constitutional conspectus, so that you decide whether it is possible for somebody to use another's intellectual property to make a point without having to seek their permission. So if I have the right to use the trademark of Tata to make fun of Tata on a particular issue of public interest, one, would that amount to defamation? Two, would that amount to trademark infringement? These were the broad questions. Both the questions were answered in favor of Greenpeace. And then I think I also happened to participate in the trial process fully. It was among the first experiences where I got to cross-examine the other side fully. So this, I think, prepared me on multiple grounds. Importantly, it honed my trial skills as well as a litigator. So there are multiple such experiences, but this was among the first, and therefore I thought it was memorable.
Thank you so much, sir.
Brilliant. I'll now request Mr. Samlesh Shankar Nayak.
Namaskar, sir.
Namaste.
Very happy Mahashivratri. I feel blessed to have a one-on-one talk with you. Sir, I am Samlesh Shankar Nayak, pursuing my MBA in ICFAI Business School, Hyderabad. Like sticking very specific to the topic litigation in India, we fellow are being taught company laws and legal environment of business in our semesters. So setting the boundaries till academic curriculum, how is it how appropriate is it to study, and if yes, then how to be excellent in this, and just to balance and manage legal companies laws and litigation and get concerned about these things and get ready for the upcoming litigation in business world. And second is what's your perspective of visualizing a thing the way you prepare and create judgment which eventually stays correct and logical? And third, sir, what's the mistakes you made in your career path that you will advise we students not to make, sir?
Mistakes broadly would be, so in the first 3 years of practice, or even 4 years, given my restlessness and my urge to do well and to showcase what I can do, I think my nights were relatively sleepless. I was even otherwise an insomniac. I remain an insomniac. I made my own life miserable by not realizing the pace of the profession. See, sometimes it helps to understand that you have to take baby steps before you start running. Okay. In hindsight, if somebody had told me this, I would have perhaps refashioned my formative years in the profession slightly differently. But the other side is, it was that impatience that made me do a lot of things in preparation for the opportunity. So it's like this. When the opportunity lands on your table is never in your hands. It's not within your control or your remit. But every time the opportunity presents itself, you must be ready to go ahead on the front foot and hit a six. That should be the nature of preparation, which means you're always preparing in the hope that today is the day you get your big break. And two, in the legal profession, while there are certainly big breaks by definition, there are multiple small breaks, so to speak, that give you an opportunity to present yourself to the rest of the profession. And you may not know that you've gone a certain distance, but there are people who are watching will come and tell you that you've done well or that you've reached a certain stage in the profession. So never discount or dismiss any opportunity as a small opportunity. What it can turn out into, you never know. There have been instances where we have made landmark judgments out of procedural questions, pure procedural questions, which have got nothing to do with substantive aspects. So to those people who are interested in making a career in litigation, take procedure as seriously as you take up substantive law. That's very, very crucial. So CPC, evidence and whatnot, I think it's very important that you arm yourself with those tools, because sometimes your case may be weak on merits, but procedurally you can torment the other side to such an extent that they come for a settlement. Okay, so it's important to have these tricks of trade in your bag of tricks. Two, what can you do to prepare for, let's say, commercial litigation, corporate litigation, or the challenges of it? I don't know how to answer the question from a management student's perspective. All I can say is that whether you're a lawyer or an in-house counsel or a business manager, gone are the times when you could discount legal strategy as part of your business strategy. One, it is important from a compliance perspective, 100%. Two, if you think of legal expenditure as wasteful defensive expenditure, then you will pay manifold at a later point of time. Okay. So while it may be seen as a secondary form of expenditure or even defensive expenditure, it is necessary as on date. Ask any startup today in the realm of telecom or any other business. They have to take into account the possibility that their products may be sued for patent infringement. So they have to invest in finding out whether their products are running into any patent thicket or not, whether they are stepping into somebody's territory or not. How do they anticipate for it? They have to keep a watch on the trends of litigation so that they know whether to anticipate any litigation that prevents the product launch or not. I have worked with startups to know that they have grown to the extent of, let's say, of understanding that their startup strategy or their launch strategy includes a very crucial legal component. That is also a reflection of the growth in the sophistication of Indian business models as on date. You couldn't have said this perhaps a decade ago or maybe 15 years ago. Now, legal strategy, legal awareness is indispensable whatsoever. Previously, what used to be the exclusive domain or the primary concern of big corporations is no more limited to that scale. Everyone who wants to set up his own business or become an entrepreneur has to necessarily take into account legal strategy. And lawyers on the other side too cannot limit themselves only to the knowledge of the law. They must stay abreast of business models. They must understand commercial realities, because in commercial litigation, you don't fight on principle, you fight for commercial outcomes. So therefore, there is sometimes a decent chance where you may have a fantastic case on merits, but you choose to settle because it has a better commercial outcome for the client than a fight on principle and a victory on principle. And there are instances where you may succeed legally, but fail utterly commercially because of the timing of the judgment. So lawyers must understand business and business sensitivity, and those who are business managers must equally understand the importance of law. I think it's a two-way street in that sense.
Brilliant, sir. Brilliant.
Thank you so much.
I've been waiting for this kind of a statement from you. It is at the intersection of various domains that we create a lot of value. We solve a lot of problems, and it has gone straight from you that the business managers or the owners of the business will have to include the legal component as an important part of the strategy. And that's so true even for the startups, not only the established organizations, but even the startups. That's amazing. It is extremely useful for the large young crowd that is listening to you, both on Zoom as well as Facebook Live right now. Great, sir. Thank you, sir. Ms. Harika Gaud, quickly, we are nearing 8:30, so we'll definitely respect that timeline and deadline.
Good evening, sir.
Good evening.
My name is Harika and I'm from ICFAI Law School, Hyderabad. I'm a second year student, but my question is that when I'm interested in litigation and also when I'm going to all moots which are coming up to our college, and then when I'm participating in external moots and all, I'm concerned with litigation part when I'm researching in particular topic. So what type of research do you suggest for us who are aspiring to be a litigant as famous and popular as you are, taking into consideration that you are a role model to students like us. So, how do you suggest us to research for a particular topic or for a particular case that we come across? Thank you.
So drawing from your question, always aim for credibility, not popularity. That's more important. One. Second, in terms of research, perhaps I think it helps to understand that research does not mean pulling out a particular piece of information or a judgment. Research is about understanding what is the fundamental question of law involved in a given situation. That analysis is the first step of research. The second step of research is to be able to pull out as many layers as possible from that very question so that you can break it down into multiple sub-questions and then trying to answer those questions in accordance with the position that you wish to take. So fundamentally, research does not start with searching for material, but in terms of understanding the question in the first place. My law school advisor said this, and I followed this very, very clearly all my life in terms of practice. Spend 20 minutes on the question and 5 minutes on the answer. You must be able to pull out multiple layers because that would show the depth to which you have understood a certain problem. Okay, both from a legal perspective and a policy perspective, which is legal perspective is what is the law, policy perspective is what must be the law. Okay, so you should be in a position to try and answer both sides of the question. And typically it helps if your strength or your command over jurisprudence is good. It helps you across the board. The one subject that is dismissively, let's say, taken up in the entire, let's say, tenure of your law school, where people don't pay enough attention is jurisprudence. You will realize once you enter practice that if there is a certain legal question on which there is no case law or a precedent, it is jurisprudence and first principles that will come back to help you build an argument before a court, if that is the first time that issue is being addressed by a court of law. So the test of a good lawyer is not his ability or her ability or their ability to pull out judgments on an existing question of law, but to ask whether they have the basic building blocks of an argument in the absence of a precedent to support their position. That is how I would approach it, and that's how I've always approached it. And that has helped me bring about conceptual clarity each time I've presented an argument. And that is what improves your ability to also think on your feet when you're confronted with a question for which you don't have any case law support. So research backed by, let's say, fundamental concepts of jurisprudence is how I would go about it. And see, there were times when people had to go to libraries and go through multiple commentaries and subject themselves to sheer torture to decide what is good. But in the process, they would read hundreds of judgments to decide whether it is relevant or not. Today, you have an online database. Plus, the savior for all of us is the Control F option, where you can actually search for the keyword directly. You can do all of this. With all these tools available at your disposal, your job is now reduced to framing the question properly. Once you frame the question properly, 50% of the job is done. And that is where the maximum amount of mental effort is called for. So framing a question and pulling out multiple layers, I think, is the definition of research.
Thank you very much, sir. Thank you for this 123 minutes of brilliant talk, addressing lots of questions and satisfying us in terms of our learning zeal to actually listen to you and try and put certain pieces together and see what works for us back. back in our profession as well. For example, several things that you have mentioned made lots of sense to me and many others around the screen also, in terms of the fact that the very last question that you answered, define the problem very well. A large part of your effort and energy will fructify if you have defined the problem so well. And then the 20 versus 5, 20 minutes for defining the problem and then 5 minutes in trying to solve it. It is applicable not just in this framework of the discussion that we are currently having, but across professions, across any problem solver's context, it is very useful. The other few things that you mentioned, there are many things, but let me take just one or two and then wrap it up with your permission. As I mentioned, career crafting is something one should go by when one pays attention to this. We are going to write a summary of this session. We'll run it through you before we post it on our website. A lot of people who missed this session would love to go back and catch up. There is a text summary as well as a video, edited in the sense it is put together. And there is a potential for a lot of us to revisit and learn these aspects. Therefore, career crafting examples and some of the suggestions that you have given will definitely be useful. And trying to identify solutions, not just in individual practices, but yearning for ecosystem to solve problems. I think we all have to distinguish between individual practices, individual performances, as well as the issues that are supposed to be dealt with at ecosystem level. Very, very wonderful. These are larger suggestions, actually, not just in the legal system, but beyond even that. The other important aspect is that you mentioned some of our professions, including your profession, is a spectator sport. A lot of people are watching us. We better perform. We better craft ourselves in a manner that our learning, our choices that we make are also seen and we are judged by that. So it's a spectator sport. It's not a 100 meters dash, it's a marathon. It applies to various other domains as well. So beautifully put. And very nicely to a very tricky question, you have mentioned that ability to interpret law is very, very different from the ability to actually frame policies or legislate law. I think that is also a larger takeaway from the wonderful long discussion that we have had. And the other important aspect is a lot of what you do, some of the students who are present here, you mentioned yourself, a lot of what we do while we are still in the law school is also determining your commercial success when you actually go and practice. I think we should not get swayed by some of the things that we hear in media, and that is bound to have larger influence sometimes. But I think when you said focus on first principles, I think it is true to not just an engineer to succeed solving a lot of techie kind of problems or business problems, but it is true everywhere. Focus on first principles, and I'm sure it will hold you in good stead. Take yourself very seriously. This is a building yourself kind of a mantra. Take yourself very seriously. Otherwise, everyone else is very busy to take themselves seriously. Nobody will ever try to take you seriously. So it is for you to build yourself and take yourself very seriously. Focus on credibility as against popularity. I think this is again another important influence that one gets swayed by. To not go by popularity, but I think build oneself strongly, resourcefully, and thereby build credibility. I think these are fundamentally wonderful points that I see, which are useful for a large number of entrepreneurs who have joined, young students, practitioners in law, academics in law, and some of the civil society members also have joined from India and abroad. I thank all of them for posing a huge battery of questions. We have had about 120 questions roughly. Which, I mean, there are in addition to that, they have posted a few questions, but there's always going to be a compromise in terms of what we can pick. The learning is continuous. I request all the members who have joined today to keep writing those questions to us. We'll try and send this to Mr. Sai Deepak whenever it is convenient for him. He can probably answer on email, and so that we can share the same thing with you. But before that, sir, I want to profusely thank you for your patience, a lot of energy and expertise for these 130 minutes that you have spent with us. From the bottom of our heart, thank you so much.
Thank you. Thank you so much, sir.
Ladies and gentlemen, we will take a break here, and I wish you once again a happy Shivratri and a wonderful Women's Day. And next week, on 15th of March at 6:30 p.m., we are going to have Dr. Raghunath Anant Mashelkar. He's going to talk about transformational science leadership there are lessons from his own journey, and that will be the discussion point. Do come back. We will learn a little more. And if you have any doubts about the litigation landscape in India and abroad, and you want to compare, go through some of the blogs posted by Mr. Sai Deepak, some of the videos that you have, we need to learn from. I think you can go and visit that. Try and filter your mind, what to avoid and what to focus on, what to learn from, what to be implemented and make it useful in your own career building. I think there's a huge effort out there, and there's a huge lesson for us to go by. Thank you so much for joining this week, and I hope we will all be there next week as well. Till then, have a good weekend. Thank you so much and good night.